Hi, everyone. My name is Diane Donnelly. I'm with the Donnelly Group of Keller Williams Flagship of Maryland. And today I have a couple of special guests, two guests today, and Erica Redmond and Tara Frame with Frame and Frame. And we're going to talk about a topic that is very interesting and one that I learned a great deal from just from doing some research to prepare for today's call. And it's about guardianship. And I want to introduce Erica to you. Erica has a practice which includes family law, divorce, alimony and spousal support, custody, visitation, and child support, wills, trusts, and powers of attorney, estate planning and probate, guardianships, deeds, truck accidents. I'm still going. Motorcycle accidents, motor vehicle accidents for the plaintiff. And you all have met Tara, and Tara does the estate planning as well. And I just wanted to say hello to both of you. And Erica, if you wanted to just fill in any gaps that I may have left off, and Tara, same for you. But why don't we start, Erica, with you?
No, hello, Diane. No, you did not miss anything, and it sounds exhausting when you say it, but yes, I handle all that in the office.
Excellent, excellent, fantastic. And Tara, did I leave anything off for you?
No, so yeah, my areas of practice, I focus on the estate planning, so wills, trust, powers of attorney, elder law, which includes long-term care and Medicaid planning, and probate and estate administration. So those are my core areas of practice.
And if you guys have been following along, you've seen our series. And next week, we're going to be talking about complications or considerations with blended families. So that's going to be a good one because it's applicable to lots and lots of families. But today we're going to talk about guardianships. And Erica, will you explain to us what guardianships are all about?
Sure. So guardianship is necessary as a last resort. I'm going to say that a couple times probably today, but it is the last resort if someone cannot make their own medical decisions or someone cannot make their own financial decisions. So there's two different types. And what you would have to do is you'd have to petition the court to be able to get a guardian appointed for someone. And it can be a guardian of a minor, or it can be a guardian of an adult person. And again, there's those two subtypes of person and property.
Okay, so an example of somebody that may need a guardianship is an elderly person, for example, in the one case, and they can no longer make decisions, but they don't have a power of attorney or they didn't do any estate planning prior to. Is that right?
Absolutely, yes. Or for some cases that I have, there's a defect in the document that they completed, or maybe they completed a power of attorney and they didn't have a successor power of attorney appointed. So it's not as cut and dried as it would sound. But there also is sometimes where if it was an older power of attorney and they didn't have certain provisions in the power of attorney prior to the rules change, and I think it was 2010, they may need a guardian appointed to take care of actions they can't underneath of their power of attorney.
Okay, so
yeah, if I can jump in on that. So yeah, that when this issue comes into, for my part, it's when either they don't have a power of attorney and then they need to take care of their parents' finances. And then at that point I say, okay, well, you need to talk to Erica because she handles all the guardianships because you're going to have to file for guardianship. The other time this comes into a play a lot of times with Medicaid planning and long-term care planning is when there was a power of attorney. And like Erica said, it did not include certain provisions. So if you just use a statutory power of attorney or one that you just print off the internet, it is not going to have the provisions that give you the power to do long-term care and Medicaid planning. And then even though you have a power of attorney, it doesn't have the correct provisions. So then I have to, again, turn them over to Erica so that she can get a guardianship order from the court. So then we can then go back and do the planning.
So who determines if a guardianship is necessary? I'm going off topic here for a second. Who determines if a guardianship is necessary or if an attorney is okay? And we're either frozen or you guys can really hold your stare pretty long.
Well, because I'm going to give the classic answer. It depends. It's too broad of a topic. I apologize. So usually when they come into my office and they give me, or come into Tara's office and they give us a scenario, and I'll give you an example. So someone had a power of attorney created, but they wrote the name wrong of the person they wanted appointed. And so in theory, it's correct, but there's a defect in the power of attorney to not allow it to be accepted by a bank. And in that case, the person is already usually incapacitated, or there's questionability about whether they have like the dementia. That's the easiest. They have dementia and they can't do a new power of attorney. They can't correct the defect at that point because it's not discovered until you need to use it, of course. And so at that point, I would say you need to have a guardianship. Another way is,
I think we're stuck again.
Oh, can you hear me? Am I stuck?
I can hear you now. Yep.
Okay. So another scenario that comes about usually is that someone tells, in the cases of an older person, a doctor, or maybe they've been caught driving when they shouldn't be driving. Someone will say, you really need to get your parents a guardianship to take care of them. They're not doing what they're supposed to be doing. Or the Department of Aging gets involved and says a guardian needs to be appointed. So that's usually those two parameters. A family member will notice something's wrong and they need to do something and they can't do something, so they come to me. Or someone's been acting badly, grandma's been acting badly, and the state gets involved and says, hey, they probably need a guardianship. We're going to proceed to get one.
Okay, so what if you guys are doing, for example, you're doing an estate plan and you realize that there's an elderly person, and do you just immediately start with a power of attorney, or do you say, let me talk to the person to establish whether they are, I don't know if coherent is the right word, or if they're able to make decisions on their own? Do you guys ever have to say, okay, let me talk to this person? I know, Tara, you and I had a situation where something like that really did happen. And I think we were looking at, do they need a power of attorney, or can they sign on their own? But would that be an example of if you could establish power of attorney?
We definitely take safeguards, especially when it's an older individual, because we have to meet with the person who's drafting the document, we're drafting the document for. We have to ascertain that, number one, that's the person that we're drafting the document for, that they understand what we're drafting, and that they know once they do this what that means. And technically, the person only needs a moment of lucidity, and the onus is on us to ascertain whether or not they're lucid. And we have checks and balances on that. And there have been times where I have wondered if somebody was lucid. And in law school, a really great professor told me a trick is tell them a joke. And if they laugh, because it's a higher level of understanding, then you've probably got an understanding on it. But if I feel uncomfortable, we don't proceed. And we've had some situations where there was a time where I felt uncomfortable, and we had to tell them, I'm sorry, we can't help you. You'll have to go somewhere else.
Yeah.
Okay.
Yeah, we definitely had situations, and you ask them, general questions, who are your, what is your name? When were you born? What are the names of your children, your grandchildren? And, you ask, questions and see if they're, if they understand, and then you understand, explain to them what the power of attorney means. And if they understand that, and, if they are clear and they seem, they're alert and they're clearly telling you, I want my daughter or my son or whoever to take care of my affairs, and they understand that, then that's all you need. There have been times where I've had clients that just don't understand, and I, explain it to them, and then, if it's uncomfortable and I'm like, I'm just not comfortable doing this, so we're going to have to get a guardianship. I'm not willing to have them sign this power of attorney. We're going to have to take a different direction with this.
Okay, and I'm going to jump back to the two types of guardianship. So there's the medical guardianship, and then there is the financial guardianship. Can you just tell us the two distinctions? Obviously, I mean, it sounds like it's pretty easy. One's medical, one's financial. But is there anything that isn't covered in either of those two categories that somebody should consider something in addition to guardianship?
Not really, because at that point, it's the person, guardian of person deals with our baser instinct, what we need. So, what do we need medically? What do we need for our home life? What do we need to have a comfortable living? It's taking care of someone like you take care of a child in essence. I mean, that's what it is you're making sure that they have appropriate housing, you're making sure that they have appropriate clothes, food, you're caring for their medical needs, and you're stepping in and advocating for them as if they would advocate for themselves, the best of your ability. Financial is the day-to-day paying bills, still I guess the parent aspect of it, but it's more of being a rational human being and saying what's in their best interest, what's going to help them. You know, you're making sure that their accounts are correctly titled. You're looking out to make sure somebody's not taking advantage of them, that they're not double paying bills. I remember one case where somebody was had multiple accounts that they didn't know about, randomly giving money out, because obviously elderly people are at risk for scams and scam artists. And, the calls, we've got your granddaughter, please give us money scams. I've got calls like that.
Yep.
So you're making sure that they're safe financially, and that they're able to be cared for, and getting them resources to be able to help them, like their social security, making sure that's going where it needs to be, making sure that they're the rep payee. So it covers pretty much everything. But something that people don't realize is that even though you're appointed the guardian, the court is the ultimate guardian, which is why I say it's the option of last resort, because the court has the ultimate decision-making power on some of these cases. And so you have to ask the court permission to do certain things. If you want to rehome the individual, you have to ask permission to do that. If you want to sell their house, you have to ask for permission. If you want to, sometimes depending on the situation, you have to ask about life cessation, and you have to ask the court to do that. So and
Really?
even to withdraw funds. Yes. Guardian is not an easy process. It involves a lot of court oversight, which it should in all reality, because you're asking someone to basically say that they're not capable of caring for their life, and you're appointing someone to take away all their rights and responsibilities. It's scary in some senses, and it's a very big task for somebody to undertake, and the court requires you to do training in order to do it, and they require yearly reporting to them.
Yeah, because I mean, if you have a power
For all
of
the financials too, right?
Yes.
Yeah. I mean, if you have a power of attorney, you've made that decision. You're appointing someone that you trust to take care of these things for you and to make these decisions. But if you don't have that, then it's up to the court to appoint this person who they think is going to be the most responsible person to do it. And in that case, then they want you have to file annual accountings for every dollar and cent that goes, that the person has, every expense. You have to provide receipts. You have to provide bank account statements. And the guardianship clerk, they cross-reference all of those account statements with your inventory and your annual accounting to make sure that it's all correct. And if you misappropriate funds, or you spend something on an expense that wasn't approved, like an atypical expense that wasn't approved, the guardian's going to be responsible for putting that money back into the account until the court approves it.
Right. So, and also with that, you have, the court can call you in. They can do a show cause order and call you into court and say, what have you been doing? What's happening? And the court obviously has the power to refer you, if necessary, for criminal actions as well. So it's a big deal. It's a big undertaking. And I hate
it's unfortunate that.
Yeah.
Well, and and it does come into it happens. This is a situation that
I think I frozen there for a second.
Okay, this is a situation that happens a lot, is people, when they call me to maybe do estate planning or talk about elder law, Medicaid planning, I say, well, what about powers of attorney? They say, well, I have the one that I got at the hospital. And I said, you mean the medical, like either the MOLST form or a medical power of attorney or a healthcare directive? And that's what they end up having sometimes, but they don't have the financial. So then when they need to go in and pay the person's bills, they have the medical, but not the financial. So then you're in a situation, you're going to have to file for guardianship of the property so that they can pay their bills and take care of their financial affairs day to day.
Is there something called a contested guardianship?
Yes, yes, there is.
That's like a family
As a matter of
policy.
fact, there is.
That's basically custody of an adult.
It is, and it honestly, I gotta tell you, none of the family law stuff is ever enjoyable, and guardianship is a subset of that, and everybody's unhappy with it. Everybody's unhappy with the decision of the court. Everybody is mad because they're talking about one another and how bad they are, how bad they've treated mom or dad or their child or whatever it is, and it tears families apart. It really does. And I have to have that talk with clients. This is going to completely upend your family. Do you understand that? Like, this may never repair, and it's never enjoyable. The families hate it. The parents hate it. But it has to happen. It's for the better. It's for the alleged disabled person.
Right.
Yeah.
So
I think there are situations where, and I was gonna say, I don't think this has been, I'm not sure if Erica had mentioned this before, but there are situations where a power of attorney is in place, but that person is misusing the power of attorney. So another sibling has come and said, look, my sister has a power of attorney, but I think there's something going on. Like, all this money is just being spent, and she has a brand new car, and she has this and that, and I know she can't afford this. So what's going on? And then a guardianship would be filed, asking the court to appoint someone else, and then that would override the original power of attorney. So the court order will replace that person and void the power of attorney, and then appoint a legally appointed guardian.
So how long does it take? So say somebody comes to Erica and Tara and says, I need a guardianship. Walk me through the process. What is the time that it would take to do one of those? That's just something like that cost.
A contested guardianship? Sorry, you froze up.
Nope.
A little bit.
Nope. Just a regular guardianship. Somebody comes in and says, like, am I getting frozen?
A little bit, yeah. Sorry. So if it's I'm going to give you pre-COVID because, as you know, when COVID happened,
Can you guys hear me?
I can hear you.
Yeah.
You're not moving. You're still frozen for me. Good. Okay, now you're moving. So
okay, good.
So
did you hear me, Erica? I was saying, if somebody comes into you and there's no it's not contested, and they just say, my mom is unable to make decisions, I need a guardianship, and everything's clear across the board, everything's legit, and they come to you and they say, I need this guardianship. How long does something like that take? What is the process to go through, and how much is something like that arrange?
So again, I'm going to give you pre-COVID and kind of where we are now, because the court shut down and things are different now. So if someone were to come in my office pre-COVID, I would say 3 to 6 months, depending on the court, because each court is different. Each county is different because we have different amounts of judges, different amounts of caseloads. So it's different. There's that, it depends, exception there. But generally speaking, they would need to get 2 certificates from a doctor or a psychologist or a social worker. And they're very specific forms that they have to complete prior to filing the petition. If there's multiple siblings involved, if there is a prior power of attorney or healthcare power of attorney, I may want to get consents and then a resignation of the power of attorney for whatever reason, because that's happened. Because when I send it into the court, I want to have everything as much as I can completed. So the petition, the certificates that are required, and there's a time frame on those, they expire. So there's a time frame, they have to be filed. One has to be within 21 days of your filing. And then the consents, I file the consents in there again to tell the court, hey, it's all good. It's all free and clear. Nobody's going to contest this. The court can, and usually does, appoint an attorney for the alleged disabled, even in an uncontested hearing, because they deserve to have representation, because they don't want somebody running around saying, oh yeah, they consent, don't worry about it. Even if they are deemed to be incompetent, they still get to have someone represent them. And that attorney meets with the alleged disabled, talks with them, finds out what they want, and represents their interests. And After that point, there's what's called a show cause order issued. And I have to, as the filer, I have to notify every person who would need to be notified according to what the court tells me, including the Department of Aging sometimes, or the Department of Social Security. And after I do that, the court sets a hearing. And it's, again, it's that 3 to 6 month window, because we have a time frame under the show cause. It's usually about 30 days, or 20 to 30 days to get that done. And we have the hearing, and it's pretty easy. Again, before COVID, you would go to court physically, and you would have to bring the alleged disabled with you, or the attorney would appear without the alleged disabled, depending on the situation. We'd give some brief testimony, and the court would issue its order, and that's it. And it's really more simplistic that way. And I don't know if Tara touched on this, but in powers of attorney, we designate guardians. So if for any reason, if you couldn't use the power of attorney, you have a designated guardian. So we can actually use that to say, hey, court, when they were competent, they wanted so-and-so to be their guardian, if ever necessary. And so at least they're heard when they were competent as well.
Okay. Okay. And in that meantime, 3 to 6 months, and mom needs some medical advice, who's making the decision for her in that gap?
So that's the fun thing. So within HIPAA, as you know, HIPAA is the greatest and worst thing at the same time. If ever you've had a loved one who was in the hospital and you needed information, HIPAA either prevents you from getting information, or it allows you to have some kind of interaction. The doctors have some ability, like if you've been taking mom to all of her appointments, they will interact with you, they'll talk with you, and technically they are allowed to elicit information from you, but they're the ultimate decision makers in reality. And I think doctors are really good at sussing that out. But I tell you, I've heard oftentimes from a lot of people where they didn't want to listen to the relative because maybe it was the antithesis of what the doctor was recommending. It was against medical advice, and they're not going to listen to person who's at the hospital, family member who's at the hospital. They're going to do what they have to based on the Hippocratic Oath. So that's kind of where that gray area is. And so that's why I try to move those along as fast as possible.
That makes sense to me. And all of this sounds like, man, get your affairs in order before this happens, right? And yeah. I know my mom's 85. She can hear me. She's 85. But, at a certain point, I should get all of that taken care of for her, thinking ahead, right? So I guess in get your affairs in order, get your powers of attorney, get the wills, get all of your estate planning done. And in the event that it doesn't get done, guardianship is the way to go. And then they reach out to you to learn about what the next steps are, how to do it, how to prepare, considerations, what should be thought through, those kinds of things. Am I right on all of that?
You're absolutely right. And I want to scare people a little bit, because generally speaking, if it's a contested case, we talked about the uncontested cases, you're looking at over a year.
And a lot of money.
And a lot of money. And I won't say
and
money.
A lot of money.
And a lot of money. It's more
time.
It just depends on what has to happen. And the price of doing the pre-planning versus the price of doing the guardianship is worlds apart. Mm-hmm. The worst thing my clients say to me, but I understand, is like, I really like you, but I don't want to have to keep paying you. And I understand that. It's like they love dealing with me, but they're like, I don't want to have to pay you. And I get that. But
right. I don't want to pay your mortgage every month.
And it's not me. It's not me doing it. It's usually what's going on in the process. And it's the end fighting, the families arguing over mom or dad or children or what have you. And it's sad. And I don't like having to do it sometimes, but it's necessary. I mean, you can't leave mom. You got to take care of your mom. You got to take care of your kids.
Mm-hmm. Yep, absolutely. I have a really bad connection today for some reason. Something must be going on with my wires, but can you guys hear me?
Yeah, we can hear you.
Yeah.
Okay. I keep getting stuck and I don't know if you can hear me or not. So I want to give you guys the floor to say anything that you want to say. But again, in parting from my side, I hear stories all the time being in real estate that things just weren't planned out and here's what happened. And then you're dealing with just difficult situations. And I want to implore upon everybody here that's listening to please get these things in order. It's not that expensive. When you break it down, what it saves you on the back end, it is well worth it. Stay off the internet. It stinks. It's not going to protect you. Get with a local attorney who knows what they're doing. And hopefully, you know, these guys are obviously the pros. But get sound advice, not internet advice, get sound advice from people that are doing it every day and can share experiences with you. And then Erica and Tara, do you have anything left to say? Otherwise, we're going to put at the end, we're going to have some information about how to reach you guys so that if people have other questions about guardianships, powers of attorney, or any estate planning, they can reach out to you. But anything on your end that you want to say in closing?
Go ahead, Tara.
Yeah, I mean, I would say, like, again, just the importance of pre-planning, because we didn't even talk about, you know, minor guardianships when, you know, when you have if you don't have a will and you have someone under the age of 18 that inherits, even if they have parents that they live with, the parent has to get guardianship because the court is not going to let an estate distribute $100,000 to under 18. There has to be an oversight. If you have a will, you're going to either name a custodian or a trustee in the will. So that's taken care of. But if there's no will, again, it ends up in the court system. And there's a lot of hoops that we have to jump through to get it all done, unfortunately, to protect the child and the inheritance. So pre-plan. It's just so important. We have lots of guides on our website. So if you go to frameandframe.com, we have all kinds of free downloads that you can download, lots of guides with good information. And then, you know, we're always available to answer questions to people. So you're welcome to email us or contact us through our website or give us a call in our office. Erica?
Don't forget
Excellent.
our YouTube page. We also have a YouTube page. So it's got quick informationals, little quick videos with some information. We also have some really great blog posts that we have up there to take a look at. And yes, we are available to answer questions because 9 times out of 10, I would rather you come to me with your internet paper before you try to use it and tell you you shouldn't be using this. This is not correct, because I did talk about criminal penalties. If you do something wrong, you could have the best intentions in the world and you could do something that's not appropriate with somebody's money. And you could be in trouble. So always talk to somebody, at least a consult, to find out what's going on, what you need to pre-plan for, what you need to be aware of before you go down the internet road to get your information.
I've heard too many bad stories about that internet road for something that is so critical. Like, I absolutely do not ever want the courts to make decisions that for me, or my mother, or anyone I love, I don't want them making decisions. I would rather pay a couple of $1,000s in advance to take care of it the way that I want to take care of it, or the way that my mother wants me to take care of things, not the internet, not the courts. They stink.
They don't want to either. Let me be fair. The courts do not want to make these decisions either. They do not enjoy this.
Yeah, no, I don't think there's an enjoyable part of it. So pre-plan, right?
Yep.
Yes.
Yes. Okay, you guys, thank you so much. I appreciate having you guys both with us today. What a special treat to have 2 of you. There's information on how to reach Erica and Tara below, so please do. And we will see you in another week next Wednesday, and we'll be talking about blended families and considerations. So we'll see you then.